Dissatisfied with the findings made and the remedial actions taken, the President, the Speaker of the National Assembly, the National Director of Public Prosecutions launched a review application challenging the Public Protector's report. This report was challenged on the grounds of unlawfulness and irrationality. The Public Protector and the EFF opposed the review application. Amabungane Center for Investigative Journalism was granted leave to join the case. Amabungane asked the High Court to interpret the code as requiring disclosure of donations made to campaigns for internal leadership of political parties. Alternatively, it sought to challenge the validity of the code. The High Court delivered a comprehensive judgment on the matter within a period of a month. That court upheld the argument that the findings made and the consequent remedial actions were unlawful and irrational. With regard to Amabungane's case, the High Court interpreted the code and concluded that in its present form, the code does not require disclosure of donations made to internal campaigns for leadership of political parties. However, no decision was taken on the constitutional challenge against the code. The Public Protector, the EFF, and Amabungane were unhappy with the outcome and sought to appeal directly to this court. We were satisfied that these parties met the requirements of a direct appeal. The issues that arose are similar to those that were raised in the High Court. They are A, whether the Public Protector correctly found that the President had misled Parliament in breach of the code. B, whether the President had a duty to disclose donations made to the CR17 campaign and whether the Public Protector competently investigated this issue. C, the Public Protector's competence to investigate the affairs of the CR17 campaign. D, whether the Audi principle applies to the process preceding a decision on remedial action. E, whether the remedial actions taken were lawful, and F, whether the High Court rightly declined to adjudicate Amabungane's constitutional challenge. Each of these issues was considered separately by this court. The first issue considered was whether the President misled Parliament. The inquiry into this issue was partly factual and partly legal. The standard for determining whether there was a breach is to be found in paragraph 2.3a of the code, which reads, open quote, members of the executive may not, A, willfully mislead the legislature to which they are accountable, close quote. In plain words, the code prohibits members from willfully misleading the legislature. The member concerned must have intended to mislead by furnishing incorrect information to the legislature. The underlying reason for this qualification is that members of the executive rely on information given to them by departmental officials, the correctness of which they are not in a position to verify. The evidence placed before the Public Protector did not establish willfulness on the part of the President when he answered the question by Mr. Maimane on 6 November 2018. In fact, it appears that Mr. Maimane himself was not aware that his question was factually incorrect. He thought that the payment of 500,000 rand was made to the President's son. Hence, he was concerned about the improper relationship between African Global Operations, whose CEO had paid the amount, and the President and his family. At the time the answer was given, all parties concerned thought that they were dealing with a payment to the President's son. It was only after the parliamentary session that it was brought to the attention of the President that the payment into the EFG2 trust account was a donation to the CR17 campaign. And he sought to correct his answer by addressing a letter to the Speaker. Even then, Mr. Maimane did not accept that to be true, and he continued to submit a complaint to the a complaint on the improper relationship between African Global Operations and the President's family to the Public Protector. Mr. Maimane had in his possession an affidavit by Mr. Petros Fenta, who made the payment and had said in it that the money was for the President's son. However, the investigation by the Public Protector revealed that Mr. Fenta was wrong on this issue. Now, the question that the Public Protector had to establish was whether, as she was requested by the complainants, the President had willfully misled the National Assembly. These were the terms in which the Deputy President of the EFF had framed the complaint, and it was correctly framed in the language of paragraph 2.3a of the Code. It appears from the report that the Public Protector accepted that the President was not willful. In one part of the report, the Public Protector recorded that the President's open code conduct referred to above, although in good faith, is inconsistent with his office as a member of Cabinet, close quote. But instead of making the finding that the President did not willfully mislead Parliament, the Public Protector effectively changed the wording of paragraph 2.3a to include deliberate or inadvertent misleading of the legislature so as to cover the situation where willfulness was not established. On the basis of the changed code, the Public Protector concluded that the President, open quote, inadvertently and or deliberately misled Parliament in that he should have allowed himself sufficient time to consider the question and make a well-informed response, close quote. The Public Protector was wrong to change the code. She could not have conceivably thought that willfully could mean inadvertently. These words are mutually exclusive. What she did went beyond the parameters of interpretation, but the finding itself is framed in terms that are concerning. The President could not inadvertently and deliberately mislead Parliament, because these two words cannot apply at the same time. It is either one or the other. Therefore, the Public Protector was wrong on the facts and on the law with regard to the issue whether the President had willfully misled Parliament, and the High Court was right to set aside her finding. The next finding is whether the President had a duty to declare CR17 donations and whether the Public Protector could competently investigate this issue. The Public Protector concluded that the President had improperly and in violation of the provisions of the Code and the Act exposed himself to a situation involving the risk of a conflict between his official responsibilities and his private interests, or used his position to enrich himself and his son through business by African Global Operations. There was no evidence supporting this finding. Instead, the evidence showed that African Global Operations donated 500,000 rand to the CR17 campaign. This cannot by any stretch of be interpreted to mean that the President used his position to enrich himself or his son through African Global Operations. Both the President and his son knew nothing about the donation. Even if one were to accept that the bank records relating to the EFG2 trust account showed that one of the beneficiaries was the Cyril Ramaphosa Foundation, this does not support the finding made for a number of reasons. First, the link between the EFG2 account and African Global Operations is the sum of 500,000 rand donated by the CEO. There was no evidence that the African Global Operations ever made a contribution to the funds in the EFG2 account other than this amount. Second, there was not a shred of evidence that African Global Operations or the President and his son had anything to do with the operation of that account. Instead, the evidence on record is to the effect that the President had no say and was not involved in the running of that account. This evidence was not disputed. Therefore, on this evidence, the President was not involved in the payments made from the EFG2 account to the foundation carrying the President's name. Under the same heading, the Public Protector also found that the President, as a presidential candidate of the ANC, had received campaign donations which benefited him in his personal capacity, and that his failure to declare those donations constituted a breach of the code. Once more, the evidence on record showed that the President did not personally benefit from the donations made to the CR17 campaign. The Public Protector may have not believed it, but she did not reject such evidence. Consequently, the matter must have been decided on the basis of that evidence. But more importantly, both these issues did not form part of any of the complaints submitted to the Public Protector. Therefore, she did not have the authority to investigate matters falling outside the complaints. This is a requirement of Sections 3 and 4 of the Act that empowers the Public Protector to investigate violations of the Code. I shall move to the next finding: competence to investigate the affairs of the CR17 campaign. The Public Protector and the EFF argued that the High Court erred in concluding that the Public Protector had no jurisdiction over the CR17 campaign. The Public Protector contended that the source of her powers is Section 182 of the Constitution, together with Section 6 of the Public Protector Act. The EFF submitted that internal party elections constitute state affair because those party elections are a step towards legislative bodies. There is no merit in the argument advanced by both parties. Both the Constitution and the Public Protector Act do not empower the Public Protector to investigate private affairs of political parties. Political parties do not perform a public function or exercise a public power when they conduct internal elections. Theirs is a private affair and not a state affair. Moving to the investigation over the suspicion of money laundering. The Public Protector found that the 500,000 donation from the CEO of African Global Operations passed through several intermediaries, and this raised a suspicion of money laundering. But the evidence placed before her dispelled all this. The donation passed through only one account and not several intermediaries. The Audi principle. The President complained that the interim report, in respect of which he was afforded the opportunity to make representations, did not include the remedial action. He contended that he was entitled to a hearing before the decision on the remedial action was taken. The Public Protector countered this argument by submitting that Section 7 sub 9 of the Public Protector Act obliges her to afford the affected persons a hearing only during an investigation. On a proper reading of Section 7, Sub 9, we concluded that a person against whom remedial action is taken is entitled to be heard on the proposed remedial action. We also held that the public protector had no authority to make the remedial action she had issued against the Speaker of the National Assembly, the National Director of Public Prosecutions, and the National Commissioner of Police. Amabungani's case. Once the High Court concluded that the code could not be read as obliging disclosure of donations made to political parties, it should have decided the constitutional challenge mounted by Amabungani. We find that the High Court erred in declining to decide it on technical grounds. That court should have decided the validity of the claim. In a dissenting judgment, Mkhwen CJ concludes that Mr. Musi Maimane lodged a formal complaint that allowed the public protector to investigate every aspect of the President's CR17 related conduct that she considered as potentially unethical. He holds that financial assistance from individual donors and even the composite amount from the CR17 campaign as an entity constitute a personal benefit to the President and creates a situation that involves a risk of conflict between the President's private interests, his pursuit of the ANC presidency with the assistance of private donors, and his official responsibilities as Deputy President of the Republic, Member of Parliament, leader of government business in Parliament, and even as President of the Republic. The President should, in his view, while still a Member of Parliament and Deputy President, have disclosed the sponsorship to the National Assembly as enjoined by the Constitution, the Members Act, and the Code. He further holds that the emails which the President effectively admits are authentic, true, and reveal that he deliberately represented a falsehood to the public protector. And this, together with his failure to disclose the private donations to his campaign, run against the very essence of his obligations laid out in sections 96 sub 2b, 83b, and 181 sub 3 of the Constitution, and the values of transparency, accountability on which our democratic state was founded. In the result, the following order is made. 1. Leave to appeal is granted. 2. Save to the extent mentioned below, the appeal is dismissed. 3. The dismissal of Amabungane's Center for Investigative Journalism, NPC's claim for constitutional invalidity of the Executive Ethics Code is set aside. 4. The matter is remitted to the High Court for determination of that claim. 5. The President of the Republic of South Africa is ordered to pay costs of Amabungane Center for Investigative Journalism in this court, including costs of 2 counsel. 6. No order as to costs is made in respect of the other parties, including freedom under law. I hand down the judgment.